When you interpret a statute or write a brief and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
What you just watched is exactly why Senator John Kennedy is one of the most effective questioners in the U.S. Senate today. This exchange isn't about theatrics. It's about exposing a very real problem in how some judges and legal scholars approach the law. Senator John Kennedy wasn't yelling. He wasn't grandstanding. He was doing something far more dangerous to a nominee who isn't prepared. He was forcing clarity. When Kennedy asks whether legislative history should matter, and then pivots to constitutional interpretation, what he's really doing is pulling at a loose thread in modern jurisprudence. And once you pull that thread long enough, the whole argument starts to unravel. This hearing shows the difference between someone who recites legal theory and someone who understands the consequences of that theory in real life. If you appreciate sharp questioning, constitutional accountability, and lawmakers who actually read what they vote on, you're in the right place. This is Congress Lens. I'm Audrey. If you value unfiltered analysis of Capitol Hill, like this video, subscribe to the channel, and turn on notifications, because we don't miss the moments that matter. Now let's get into it.
Counselor, as you know, it's hard to pass a bill in the United States Senate. Our founders intended that to be the case, and consequently, if a bill does pass, it's gone through a long, arduous process. A lot of reports issued, a lot of debate, and all of it's written down. Why has it become common practice, and do you support it, of ignoring that rich legislative history when you interpret a statute?
Well, Senator, I think the first rule of statutory interpretation is that the text is what's paramount. And that's because the text is what actually proceeded through bicameralism and presentment, which are really just the fancy.
Of course, it's paramount, but why can't the text be supplemented by looking at the history?
I think the legislative history can sometimes provide a tool to help interpret the text. And it's often in parties' briefs, and I would, of course, consider it that way. But it's just important to keep in mind its subordinated role in that interpretation, because the intention of any particular legislator does not have the force of law. Instead, the text does. So the legislative history and the intentions of specific legislators should never take primacy over the text or refute the text.
But it doesn't have to, does it, Counselor? It just gives you context.
I agree with that.
When you interpret a statute or write a brief, and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, legislative history or statutory history has provided a tool.
Sure they do. I mean, originalism, and I'm not saying they're wrong. Please don't misunderstand me. I'm just trying to understand your perspective. Originalism and textualism is accepted even by the left of center justices. And I've read opinion after opinion, lower courts as well, where they say, well, legislative history, we can't rely on it.
Legislative history cannot be relied upon to trump the language of a statute. And so when the language of a statute really is that clear, Senator, there's not that much, and it bears directly on the question before the court.
Well, let me ask you something. Does the Supreme Court sanction looking to the Federalist Papers and interpreting the Constitution?
Yes.
Why isn't that legislative history?
The process for ratifying the Constitution is, of course, different than the bicameralism and presentment process that applies to statutory text. The Constitution was, of course, publicly ratified.
No, it's not.
Well,
you look at the plain language, don't you?
Yes. But in looking at the plain language, the question we ask is, what was the original public meaning of that language? And in the case of the Constitution, the original public meaning is elucidated by the debates surrounding its ratification. And those debates are really captured in the Federalist Papers, the Anti-Federalist Papers, the ratification debates, the notes from the Constitutional Convention, documents like that. So those documents can bear directly on the constitutional text in a way that is more legitimate necessarily than the statement of an individual legislator would be vis-a-vis a statute.
Well, then when we interpret the United States Constitution, and I agree with you, that's the case. I'm just asking you whether you think it ought to be the case. Then when we interpret the United States Constitution, why do we let lawyers do it? Why don't we just hire history professors?
The history that judges are looking to in interpreting the Constitution and other statutes is primarily legal history. It's not something like, a biography of George Washington. It's instead things like statutes or, debates about statutes, the Federalist Papers. And certainly, I think law schools could do a better job and should do a better job, teaching students how to read that legal history. But it is fundamentally legal history. And then the task the judges have in reading that legal history is to draw analogies between that legal history and our modern times. And that analogical reasoning is, I think, a fundamentally lawyerly task the judges are particularly skilled at.
Thank you, Mr. Chairman.
After watching this full exchange, what stands out immediately is how methodical Senator John Kennedy is in dismantling vague legal reasoning without ever raising his voice. Kennedy begins with a simple, undeniable premise. Passing a law in the United States Senate is intentionally hard. Bills go through committees, amendments, debates, reports, and negotiations. Every word is fought over. So his question is fair. Why should all of that context suddenly be treated as irrelevant once the law is passed? The nominee responds with the standard textualist position. The text is paramount because it alone passed bicameralism and presentment. And on the surface, that sounds reasonable. But Kennedy doesn't let the answer sit comfortably. He presses where it matters, supplement versus supremacy. Kennedy is not arguing that legislative history should override the text. He's asking why it can't inform it. And this is where the tension becomes obvious. The nominee repeatedly agrees that legislative history can offer context, but keeps retreating to the idea that it must always be subordinate. And that's where Kennedy's questioning becomes surgical. He points out something every lawyer knows but few like to admit. When language seems crystal clear, judges still take a peek at legislative history just to confirm they're right. That's not judicial activism, that's human nature. And Kennedy is right to call out the inconsistency between theory and practice. Then comes the most revealing moment of the exchange. Senator John Kennedy asks about the Federalist Papers. Suddenly, legislative history is not only acceptable, it's essential. When the nominee says the Federalist Papers help explain the original public meaning of the Constitution, Kennedy immediately calls out the contradiction. Because now, history matters. Intent matters. Context matters. Kennedy's sharp, no it's not. No it's not. Interruption isn't rudeness, it's precision. He's stopping the nominee from blurring a line that absolutely matters. If legislative history is illegitimate for statutes because it didn't pass presentment, then why is ratification history legitimate for the Constitution? Kennedy doesn't reject originalism, he exposes its selective application. And when Kennedy asks why we don't just hire historians to interpret the Constitution, that's not sarcasm, it's a philosophical challenge. It forces the nominee to admit that judges are not merely reading words. They are interpreting history, applying analogies, and making judgment calls. That admission undermines the idea that judges are simply neutral referees calling balls and strikes. What Senator John Kennedy proves in this exchange is that legal interpretation is never as mechanical as some nominees want to pretend. Choices are being made. Priorities are being set. And those choices affect real people. This is why hearings like this matter. Not because of partisan points, but because the philosophy a judge brings to the bench can quietly reshape the law for decades. And Senator John Kennedy, once again, shows that asking the right questions can be far more powerful than giving long speeches. That's the kind of accountability Congress needs more of.